I just want to whip back there to Andrew Little and Ashley Bloomfield. We have questions in regard to S28 of the New Zealand Bill of Rights 1990 Act. S28 states that other rights are unaffected, and we're asking for the court for clarity if this refers to our 1688 Will and Mary Imperial Law of the 1988 Imperial Laws Act. And we are also asking that we are confused and distressed about the recent Yardley case. I don't know if you're probably familiar with the Yardley case. And yes, and section, just a moment, make sure I've got it right. Section 45 and section 46, where Mr. Hague has decided to attach all all rights, or all declarations of rights, I assume previously written pre-1990, can be attached to the S28 law. And so we'll be questioning about that. We want to specifically know under S28 which rights does it apply to. And we're also saying we're going to be asking Mr. Little and Mr. Bloomfield if this means if the 1688 Will and Mary comes under S28, does it mean that it is if certain sections of the Health Act are repugnant to the 1688 Will and Mary, if we are exempt from those laws if we can prove repugnancy. So that's why it would be more clear in the court when I had Ashley Bloomfield and Andrew Little, and if I had them there, I would have my specific questions prepared for them, and I haven't prepared I know what I want to ask each person, but I haven't planned it exactly until I have been clear with you who's coming and how much, what's the time frame and everything like that. But I do have specific questions. So that is where we've used those. Now, in the second, I'll see if you want to have some questions about that first, and then I'll talk about the second one, perhaps. Is that better, Mr. Peter?
Sure, thank you for that. And can I start off by saying that one of the things that we accept is that you guys, and I say generally, and you all may have separate or particular concerns about the law in New Zealand, Aotearoa at the moment, but we accept that there are genuinely held concerns. They may be various concerns, but there's certainly a genuine concern about the state of New Zealand law at the moment, and perhaps how it's been developing recently as well. So that's sort of a given from our perspective. We're not suggesting that you're running any sort of false claim here. It's absolutely accept that there are genuine concerns. So I want to make that point right from the outset. The second point is just perhaps to try and explain a little bit about our reaction to your claim. And it's, I guess lawyers are not the most popular profession in the country, probably not in any country actually, but one of the things we do try and do if we are trying to do our job properly is to try and understand the concern that people have and see what we can do about resolving that concern and what's the best way of resolving that concern. So that's what we should be doing as lawyers, and that's what Bex, Rebecca, and I are committed to doing in this case, to see what we can do to advance this case along. Not for you. I need to make that plain. Obviously, we're not your lawyers, and we can't act as your lawyers, so we need to be absolutely clear about that. But we are looking to see how we might best resolve this, because a resolution that's in everybody's best interest is often the way in which matters are best resolved. We look for a resolution that everybody, if we can, get something out of the resolution. But that may not be possible. It's not always possible, but that's what we'd be looking for. Now, in terms of the issues that we have about the procedures, I think lawyers sometimes get accused of just being wordsmiths. They're too concerned about the words and everything like that. But that concern arises because we need to try and understand a claim that's being brought. And so if you've got a claim that somebody has stolen something from you, you will say, well, this person on such and such a day stole something from me, and I want to get it back, or I want to claim money for the value of whatever it was that was stolen or damaged or whatever. And you can sort of understand that claim, and you put that to the court, and you make submissions from both sides, and eventually the court will rule in favour of the applicant or in favour of the defendant, depending on the court's view of the law. Now, our problem, I guess, with what you guys, and I'm sorry if you guys, it's not a very nice description, but the claim that's been brought, I should say, is that it just doesn't fit into that sort of type of proceeding. It's not really understood as a claim for damages or a claim for that something's been unlawful or something like that. There's references to various very important parts of New Zealand history, which we acknowledge and accept as important parts of New Zealand history. But then it goes on, and when it gets into the complaints that are made about New Zealand law and the remedies that are being sought, it starts getting a little unclear to us. And I'm not intending to be rude to you by saying that. I'm genuinely saying we are trained lawyers, but we're just having trouble understanding it. And if I look as an example, just as an example, at your first application for relief, you're looking for a declaration.
Did you mean the first prayer for relief?
Yes, the first application for relief under Prayer A declaration.
Are you looking at the prayers before prayers?
Yes.
Yes, not the cause.
And that's not the causes, the prayers in the statement of claim. Is that right, Peter?
Yeah,
that's exactly right.
Yeah.
I'm just using this, Catherine, as an example of the sort of issues that we're facing in responding. The first Prayer A declaration is to consolidate the acts of the Native Rights Acts, and it's not clear exactly what that consolidation would be with. It's not clear to me how they would be consolidated or with what, and where the new declaration deeming European progeny and native Māori progeny could come from. The court needs a jurisdiction, and I'm sorry again for using the technical phraseology, but the court needs a jurisdiction to be able to make a declaration like that. And it seems to me, on the wording in that prayer, that what's being sought is a declaration from the court that the people you identified there, New Zealand people, if you like, are subjects of Her Majesty Queen Elizabeth of the United Kingdom, and there's a legal problem with that because obviously our Queen, same Queen, Queen Elizabeth II, but is the Queen of New Zealand and her realms, not Queen of the United Kingdom, which is a separate country, obviously. So I'm not saying all this to be sort of throwing confusion around or anything like that. I'm just saying those are the genuine questions I have about that prayer for relief or the declaration that's sought there and what it actually means and where it might come from and all the rest of it. So that's just an example of the problems that we have had as we read through their statement of claim. I guess if I can just make a couple of other points and then let you guys have a response. And I think what I can say is I can stay a bit longer than 2:30. There is pressure on us as you kindly acknowledged, but we can stay a little later than 2:30, I think. Just to carry on.
Our Zoom meeting will die within 40 minutes, but
it doesn't close. I don't think it closes because when I set a time on the Zoom meeting, it doesn't close. But if it does, we can come back in, I think. Okay, we hope. Okay, so let's keep going. Okay, keep going. Yeah, sorry.
And my next point is really in terms of some of the concerns that you've expressed in there are about the Bill of Rights, the 1688 Bill of Rights, and I can understand your reference to that bill and the fact that sometimes there can be confusion between that and the Bill of Rights 1990, the New Zealand Bill of Rights Act. And sometimes lawyers have that confusion too. So I can sort of understand that, but I'm just wondering what purpose would be served by a declaration saying that the Bill of Rights 1688 is different from the New Zealand Bill of Rights Act. We would acknowledge that that's the case. We'd also acknowledge that the 1688 Bill of Rights is part of New Zealand's law and comfortable about doing that because that's the fact of the matter. So there are some things that we might be able to actually agree on that means that we don't need to actually go to the court and have have some litigation over things. And I guess although the popular view is that lawyers always love to be in court, in fact, that's not always the case, and I think we should be looking to see whether we can resolve situations outside of courtrooms if we possibly can. Now, that doesn't mean that MPs, ministers, public servants shouldn't be accountable. That's a really important part of the work that public servants and politicians do. Accountability is to the electorate and to the wider New Zealand population. It's not an issue either. But just to pick up on one point you made, Catherine, and just to be clear from our perspective, I don't share your view that this is a means of getting the Prime Minister or the various other ministers or even Dr. Bloomfield to give evidence or even to get before the court to answer your questions. And that would be a matter ultimately for the court to decide. I accept it's not for me to decide that, but I'll tell you why I take that view. And that's because the issues that you're raising in this application are not really questions that the Prime Minister or Chris Farfoy can answer. It's not because they weren't ministers back in 1990 or obviously they weren't ministers back in 1688 or in 1860. So, but that's not the reason for it. The reason is that they would be called to give evidence in a case if it's a case about their roles and responsibilities. And so if, for example, as in the Yardley case, you were challenging something that Dr. Bloomfield had decided, or something that Andrew Little had decided, then it may well be appropriate to have Andrew Little to give evidence in response to that claim. Usually, it won't be the minister appearing in person to give evidence in response to the claim. It will normally be by way of affidavit in a written form. But in this case, my view of the matter that's been brought is that it wouldn't be a claim that you would call the Prime Minister to give evidence on. I wouldn't be looking to call the Prime Minister in response to this, because these are not issues that the Prime Minister has sort of responsibility for, unlike a matter that falls within the portfolio of the Minister of Health. And I don't say that to get the Prime Minister or anybody else, including us, off the hook. I think there are other ways of addressing accountability, which may be by way of Official Information Act request. There may be other ways of doing it. But I just want to be clear that as I see the proceedings at the moment, we would not see this as a means of getting ministers in front of the court to answer the sort of questions that you're posing. So I know all of that will be sort of unwelcome, and probably you disagree with large parts of it, and that I guess is something that we will need to take back to the court. But I thought it might be useful just to try and set out where I was coming from on this, and hope that you would get a better sense of our problems with what you've put into the court. So that's me, at least at this stage. Sadly, you won't be able to avoid hearing from me again as this carries on, but that's enough for me in the meantime, I think. And Rebecca, I'm not sure if you've got anything to add to that, but if not, then perhaps Catherine or somebody else could respond.
No, I think we should hear from Catherine again.
Okay, so you've raised many points there, Mr. Peter. So I'll try to address all of them with you. The first point is the monetary gain, and that I can tell you that a declaration of right has got absolutely nothing to do with monetary gain, and we're certainly not seeking any monetary gain at all. What we're saying is,
we understand that. I think. So we understand that. I think Peter was just giving an example.
Yes, I know. And the remedy.
Money.
Yes, we know. But the declaration, he's saying, how can we give what is the remedy that we can give? Because usually when somebody does something wrong, you will get a remedy of some money or some kind of thing. But there are other types of remedies, and there are remedies that the issues that I have raised in there, if you see down the bottom at the conclusion, that I have said to the judge, we're not asking him to make rulings on any of the above, because we do intend to take all of those issues to court in separate cases. And so presently our first point of call is the whole country is in a sea of confusion, and they have been for many, many, many years now, and it has piled up and piled up. Parliament after parliament, lawyer after lawyer, judge after judge, and we are now at critical levels. The country is in distress. People can't cope with it, and people are not functioning anymore under this. I don't even know what kind of legal system you think you've got going there, but it's not correct, and we all know it's not. We might not be clever, but we know that this is not the way for law to be used against people. Now, in the Will and Mary, it does have a section in there that says the people have the right to have arms according to the law. And so everybody automatically thinks that this is talking about guns when it is not. the law is also an arm to protect ourselves with. And the law is an arm for us to protect ourselves against governments when they are ruling us by tyranny and no constitutions and arbitrary powers and removing. And I'm saying that it can be used as a way to law can be used as a way to protect us, but it also can be used as a weapon against us. And we're saying that there has been a constant bombardment of legal waterboarding on the people of New Zealand. It's like people look to the left, they've got all this stuff stacked up, they throw out one new policy to the left, and when the people are focused on fighting that, they throw something out on the right. And when the people have run over to there, they throw something to the front, they throw something to the back, up, down, left, right, all around. And I'm saying that the people can't function like this anymore. So our first point of call is to come and ask for this declaration to establish. We want to have it established. Which is the highest law? Which is the consistent law? The consistent law that we can go to when we're swimming around in thousands of laws that nobody understands. And so I think it's a very clear request. The declarations were issued in 1844, 1847, 1865. I'm a little bit confused, as you are, about the 1908. Because it's not as clear as the 1865. The 1865 clearly states that the people of New Zealand, all the people of New Zealand, will be governed under the Queen's law. And when it talks about the Queen's law, obviously the Queen's law is not talking about subordinate laws. The Queen's law is talking about the imperial law that have protected us. And when the people were sent on the ships to New Zealand, the promise of the treaty, the promise of both parties, both imperial, both the companies, and from the New Zealand chiefs, that the people would have travel with them their imperial protections. And under the imperial protections, it is a forever document that is to be descended. It is a will, it's the will of Jesus, and it is the will that is to descend with all people born to us. Now, we know that 2.5 million people have been infiltrated into New Zealand over the last 10 years or so, and we don't have the absolute figures, but it's looking like many of those people do not hold their subject status. And so that's why they brought this. I know what this 1990 Bill of Rights is, and I don't believe, in my opinion, that it is for us. I believe it's for them. It's a workers' right, as was said in the Yardley case. It was a machine for immigration to use for workers' rights, and specifically for people that were not able to claim their subject status. Now, we 3 million New Zealanders have the right to claim our subject status, to be governed by our subject status, and to have it upheld. Now, in regards to the jurisdiction of the court and the Queen of New Zealand, well, under the 1901 Australian Commonwealth Act, I say something to you, Mr. Peter. We want the truth. Presently, the people of New Zealand, we don't know who's governing us. We don't know if it's the Queen. We don't know if we're in the Commonwealth. We don't specifically know whose governance or whose jurisdiction we're under. And it's time for the Parliament and the government and the judges to front up and tell us the truth. And so we are making efforts here to force their hand. We want to know. Now, if we're not under the 1688 protections, we can deal with that, and we will fight that in the court also if that comes to the case. But all we want to establish is which law is the supreme law. We know that the 1986 is an unwritten constitution, whatever that means. There's not a country in this world. There are 3 countries that don't have a constitution: New Zealand, England, and Israel. We don't know why that is. No country has ever been ruled without a constitution, and an unwritten constitution is not a constitution. So it just isn't. And ruling by convention. Now, that you said to me, so the jurisdiction, I think that
just in case we jump off, I'll set up another meeting and send you the link again.
Oh, thank you, dear. Okay, so if it goes off, we're all going to be coming back, and Ms. Rebecca will send us a link, but I'll keep going until we do. If I see we're going off, I'll come back. Can you still hear us, Mr. Peter?
Yeah, no, thank you, Catherine.
So the jurisdiction, to my understanding, it is going to end. The freeze